The Mutual Release from Purchase Agreement form brought to you by the Indiana Association of Realtors Department of Legal Affairs.
The mutual release from the purchase agreement provided by the Indiana Association of Realtors actually serves three purposes. One, it releases the parties from all rights, duties, and liabilities concerning the sale and purchase of the property, meaning neither party can sue or be sued by the other party. Secondly, it releases the parties from their contractual obligation by rendering the purchase agreement as having no effect. And finally, it specifies the party to whom the earnest money will be distributed. In a nutshell, the mutual release from the purchase agreement extinguishes any and all claims a party to the contract may have. This is the best case scenario before either or both the buyer and seller move forward with their real estate needs. In order for the mutual release to be effective, it must be signed by the parties to the agreement. Therefore, any buyer and seller who executed the purchase agreement needs to sign the mutual release. Some people have asked, why is there a signature line for the brokers on the mutual release from the purchase agreement? For this answer, we need to refer to the listing contract. According to the listing contract, if the seller is entitled to keep the earnest money, the listing broker may keep any portion of the earnest money up to the amount the commission would have been in order to compensate the broker for expenses, services, and advertising. However, if the listing broker signs the mutual release to the purchase agreement, they may be forfeiting their right to pursue any of the earnest money they are entitled to under the listing contract. It is important to note that the signatures of the buyer and seller are the only ones required to terminate the purchase agreement. Having a signature line for the brokers also ensures that the broker is aware of the mutual release and is noticed to the broker holding the earnest money that it should be released in accordance with the mutual release. Why is a mutual release required when the buyer fails to submit the earnest money in the time frame stated in the contract or at all when the agreement says the seller may terminate? Contract law is complicated, and there are not always bright lines to go by. Let's just say that some breaches are worse than others. There are some breaches that cause one party to have damages, and some that don't. Because earnest money is not a consideration for the contract, the failure to produce the earnest money on part of the buyer is not a material breach of the contract. In other words, the contract can still be performed by both parties because it can still go to the closing table, and the seller will not be harmed by the buyer's failure to submit the earnest money. However, because the purchase agreement provides instructions that the seller may terminate if the earnest money is not submitted timely, the seller may submit a mutual release to signal the seller's intent to terminate the agreement once the earnest money has not been received by the stated deadline. Because the purchase agreement is a bilateral contract and the breach is not material, it will require the agreement of the parties to terminate. As with any bilateral contract, when the parties cannot agree on the termination, either party may ask the court to terminate the contract based on a breach of the other party. Further, according to Indiana license law, once it is evident that one party intends not to perform the contract by submitting a mutual release, and the parties don't agree on who will receive the earnest money, then the broker who is holding the earnest money may send out the 60-day letter to the parties. According to this statutory process, either party may file a claim in court in order to dispute the decision made by the broker before the 60-day period expires. Here are a couple other common questions about the mutual release. Can the property be put back on the market as active before a mutual release has been signed? The question pertaining to the status of property in an MLS or BLC is really one for your listing service provider. From a legal perspective, a contract is still in force until it terminates in some way. From a code of ethics standpoint, Standard Practice 3-6 says that realtors shall disclose the existence of accepted offers, including offers with unresolved contingency, to any broker seeking cooperation. This means that if a property is still under a contract, it cannot be represented by a broker that it is not. Can the property be put back on the market if the earnest money has not been released? The disposition of the earnest money has no effect at all whether the property can be marketed after a purchase agreement has been terminated, either by mutual release or otherwise. Why is there no deadline on the mutual release? Simply put, having a deadline on a mutual release would not really serve any purpose. Once a party has presented a mutual release to the other party, they have signaled their intention to not follow through with the transaction. There would be no legal consequence to a party if they failed to respond to a mutual release by a deadline. It is important to keep in mind that as brokers, your goal is to not only get buyers and sellers to enter into purchase agreements, but also to ultimately close the transaction. As attorneys for the Broker Association, we strive to produce contracts that will help you make that happen. Of course, market conditions may have an effect on how smoothly all elements of real estate transactions, even the mutual release process, may run.
Questions on this form may be directed to the IAR Legal Hotline at 1-800-444-5472, Monday through Friday, 9 to 5.